Good morning, everybody. Thank you for your indulgence in allowing me to deliver the remainder of our course content by way of YouTube videos. So I will be doing the lecture today, which is in our third segment that deals with reintegration and rehabilitation. So that's today. And our next class, which would have been the tour of the Algoma Treatment and Remand Center, obviously, that's not taking place any longer, so I will be posting a documentary online for you to watch, and then I'll ask for your opinion with respect to some questions that I'll raise relative to that documentary. So hopefully that can be done relatively easily. It's an opinion piece, so there's not going to be any right or wrong answer, and I'll grade it accordingly. And then in our last class, which is essentially 2 weeks from today, I'll be doing our final lecture on rehabilitation. Likewise, as I indicated in class, your final paper is due in April. Your topics are now on CMS, so I would suggest that at this point you have about a month to complete the papers, so you should be starting your research in that regard. Okay, so with respect to today's lecture, what I'm going to do is I'm going to share the PowerPoint that deals with it. All right, so you should be able to see that PowerPoint now on your screen, and I'll be up in the top right-hand corner giving you the lecture. And as we go through slide by slide, there are 3 YouTube videos that I've embedded in the PowerPoint, so I'm not going to run them during this lecture. I leave it up to you to watch them on your own time, just as you can watch, in fact, this video on your own time. I'll also note that when the video is done, I'm going to send you all a Google form that basically asks that you've done the readings and watched the video. And if you've done that, you'll get a 10 out of 10 for today's participation. If there are internet connections that prevent you from watching the video, you'll still get a 10 out of 10 if you simply tell me that you've done the readings and gone through the PowerPoint slides. Okay, so let's start the lecture today. So again, we're dealing with these 3 issues: solitary confinement, probation, and parole. These particular issues are incredibly relevant when it comes to the topic of reintegration back into society. So although they all have some relationship to sentencing, which was our last major segment during the class, they are more particularly aimed toward how do we treat offenders and how do we get them ready to come back into society. So the first topic is solitary confinement. So solitary confinement, which is referred to in Canada as segregation, has been a human rights issue for a considerable period of time. There have been problems with the solitary relating to the overrepresentation of women and racialized groups. Cultural ethnicity is an issue. So in fact, Indigenous women and men are vastly overrepresented in solitary confinement. And that just makes sense, particularly with respect to Indigenous inmates, due to the overrepresentation of them across the board in custody, which we've already talked about a number of times. Awareness is rising with respect to the harm caused by solitary confinement. And in fact, it's been pretty clear that keeping people confined in a very small space with minimum human contact is what's considered to be harmful, inhumane, and amounts to torture. In 2015, the United Nations General Council adopted what have been called the Mandela Rules. For those of you who don't know how the United Nations actually works, the United Nations is made up of 193 countries who are member states of the United Nations. They make decisions as a body with respect to things that are important on a global scale. The 193 members comprise what is considered to be the General Assembly, right? And so just think of that as we would Parliament in Canada, where we have 338 members of parliament that sit and make decisions for the country as a whole. Well, the UN General Assembly does the same thing. Having said that, it's run, however, by what's called a Security Council, which are 15 member states. That is really the executive body for the UN. 5 of those members of the Security Council are considered to be permanent members. They've been permanent members since 1945, when the United Nations was put in place by Franklin Delano Roosevelt, who was the president of the United States from the early days of the Depression in 1932 up to and including the end of the war in 1985, at which point he actually passed away. But he did, in fact, put everything in place for the United Nations to be created. And then his widow basically went forward, Eleanor Roosevelt, in 1948, 3 years after the UN was created, and saw to the implementation of the United Nations Declaration on Human Rights. All right, so as part of what's going on, we have the Mandela Rules being adopted by the UN. Mandela Rules are named after Nelson Mandela, who was a former president of South Africa. But before he became president, he was imprisoned by the white apartheid governments in South Africa for 27 years. And most of those 27 years, he was actually in solitary confinement. So these rules are named after him. He became president of South Africa after apartheid came to an end in and around 1991 in South Africa. Right. So what the Mandela Rules do is they're very general. They impose they prohibit the imposition of indefinite, which means a period of time with no end date, and prolonged solitary confinement, which is clearly something of a longer term. And they outright prohibit solitary for women, for children, and people with mental and physical disabilities. Keeping in mind that these rules are a declaration of the United Nations and not a binding obligation, which simply means that the member states of the UN do not have to necessarily implement them, although a great number of member states, in fact, are doing that. And Canada is in the process of doing that at the federal level. All right, so as a declaration, the UN can enact things that require countries to do things, and they do that by way of what are called international covenants, a covenant being a contract. So they can basically issue a covenant to be adopted, and if a country, in fact, signs on to the covenant, then they have a binding obligation to put whatever the content of that covenant is, they are obliged to incorporate it into their domestic legislation, right? But that's not the case with the Mandela Rules. So the rules basically is the following: the confinement of prisoners for 22 hours or more a day without meaningful human contact, and prolonged solitary confinement as solitary confinement for a time period in excess of 15 days, right? Remember, these are very broad definitions. I can tell you that in Canada, and most particularly in Ontario, solitary confinement means most often 23.5 days in segregation. So an inmate will be locked in their cell, which we talked about this before, is about 2 meters by 3 meters. Those are the dimensions. It's going to have just that, the steel frame for the bed, a sink, a steel sink, and a toilet, and a seating area. Right? Solitary is done obviously by yourself, so it's pretty much the only instance in custody where somebody is not double bunked, at least. So having said that, 23.5 hours, so inmates are allowed to come out. One day they could come out for a shower, and the next day they could come out for yard being access to the daylight. I can tell you that if it's the yard, it's basically a very small area in the jail or the prison that does have some access to the sky above, but it's a very small area. It's not the normal yard in a penitentiary or jail where all the inmates for general population basically come together and walk around and talk and what have you. It's again, it's set off by itself. It's again very small, and when you go to yard, if you're in segregation, you're there by yourself. So again, there's no contact with anybody in that regard. All right. In Canada, in the federal prison system, and then you all know that what that is. That's the system where, in fact, somebody has been sentenced to 2 years or more. As of 2014, 2015, there were over 8,300 placements in what's considered to be administrative segregation, and that tends to be the focus to a great degree of those in segregation, because it's not used as a punishment. So even though, and this is what is called the hole, on TV and in movies, about 85% of those who are put into segregation are put in there for administrative purposes, which are essentially purposes that relate to keeping the institution running more smoothly. Deals with overcrowding, those kind of things. And so, it has nothing to do with somebody being punished for doing, for something within the prison system. So you may be put in the hole, but it has nothing to do with something you've necessarily done wrong. So that's obviously an issue on its own. Comparatively little known is about the number of people incarcerated in segregation in provincial and territorial jails. So they don't keep records as complete as you would find kept by the Correctional Services of Canada, right? So that's something that is a problem. It's because again, all jails in the provinces and territories, they all have provisions for solitary. So even small jails like, again, the Algoma Treatment and Remand Center up on Great Northern, it wouldn't have, because it's a very small jail, it wouldn't have a separate dedicated wing for solitary confinement. It would probably just have, a few cells that are dedicated for that purpose. But larger jails like those in Toronto South or Windsor or Ottawa, the OCDC, Ottawa Carleton Detention Center, they have in fact entire dedicated parts of the facility that deals with segregation. So everybody in segregation is in the same spot in the jail, and that's all those cells do, is house people in solitary. So having said that, again, 23 and a half hours is the norm for being in segregation every day. The harms of solitary confinement have been known for a very, very long period of time, and its legality has been questioned from early days. So what we have, for instance, in the United States is a decision in 1890, so it's 130 years ago, where the US Supreme Court said this about the practice of solitary confinement. A considerable number of the prisoners fell, after even a short confinement, into a semi-vacuous condition from which it was next to impossible to arouse them, and others became violently insane. Others still committed suicide, while those who stood the ordeal better were not generally reformed, and in most cases did not recover sufficient mental activity to be of any subsequent service to the community. Clearly, this describes solitary conditions that are harsher than what we have today. But obviously, it's clear that the issues around it were evident a very long time ago. So the court did this again. The United States Supreme Court found those conditions to be an additional punishment of the most important and painful character, and therefore violated the 8th Amendment of the U.S. Constitution against cruel and unusual punishment, which is the mirror provision of Section 12 of the Canadian Charter of Rights and Freedoms, which we talked about last day. Again, for those of you who don't know, the American Bill of Rights are the first 10 amendments to their Constitution, put in place in a rather piecemeal fashion after the Constitution was adopted by the United States at the time in 1787. So it was 11 years after the American Declaration of Independence. And so what they did is they didn't have any rights built into the Constitution itself. They had to be added on in a clause-by-clause basis after the Constitution was adopted. And the 8th one of those amendments is, in fact, the one against cruel and unusual punishment. Prisoner litigation is an issue that is incredibly important with respect to how somebody spends their time in jail or penitentiary, because it tends to be the only way that inmates can get their cases heard by a neutral source. So, they can, of course, if they think they're being treated harshly, complain to the correctional officers, who can then, if they choose, take it up with administration within the jail or the penitentiary. But that's incredibly internal and not necessarily a very effective way to deal with these issues, because it's that administration that's put them into these conditions in the first place. So litigation, what that does is it gets an inmate's case put before a judge. So obviously somebody who's outside of the prison environment. So even though in the early decisions, when prisoners brought this kind of litigation forward, the courts tended to take what was considered to be a hands-off deferential approach, which simply means that they left the conditions of imprisonment, no matter how harsh they were, they still left it in the hands of the administration. So they deferred to their decision-making powers, because they considered them to be more of an expert on how to properly treat inmates than they were themselves. But having said that, over the course of time, the Supreme Court basically has given life to this litigation, and has endorsed the use of what's called habeas corpus in basically the provincial and territorial superior courts, to question the lawfulness of somebody's conditions in confinement. So habeas corpus is an incredibly important access to justice. It's a writ. A writ is basically an old English concept that basically was a document that attached rights to it. A writ was something you used to obtain some kind of a decision or a goal. So habeas corpus, in fact, was something that was contained in the Magna Carta in 1215. Has been a part of English law essentially since then, and was used in England for various purposes over the course of centuries. It was adopted again by the Americans. So in fact, their constitution provides for habeas corpus. It's the only writ. It was called the Great Writ of Liberty. It was the only writ that was adopted into the American Constitution, and it's the only writ that's been adopted into the Charter. So if you go to the Canadian Charter of Rights and Freedoms, you will find the right of access to habeas corpus in the Charter itself. So it's incredibly important. So what's really useful about habeas corpus is that it essentially shifts the burden of proof with respect to the harsh conditions that an inmate may be suffering. It puts that burden onto the administration. So the way it simply works is this. So once a prisoner can show what's called a deprivation of their residual liberty. So residual meaning that some aspect of their liberty, which obviously means their confinement, if it's been changed, the residual liberty is, a changing of those conditions dealing with the liberty itself. And what happens is that once a prisoner who issues or applies for habeas corpus review gets in front of a judge and basically says, I have been treated unfairly, then the burden shifts to the Correctional Institute to, in fact, justify the decision that's been made. So that's a really useful tool. So the correctional authorities, in fact, have to prove that the conditions of confinement and the procedures used to place a prisoner in those conditions are lawful. And in this case, lawful doesn't necessarily mean legal, it means fair. All the while, the allegation of harsh conditions as a function of habeas corpus, also ties it to a breach of Section 12 of the Charter, which is again the provision against cruel and unusual punishment. So that's almost always a provision that's being relied upon. The other provision that's being relied upon is Section 7 of the Charter, which is the right to life, liberty, and security of the person. Courts have also concluded that lockdowns due to staff shortages amount to cruel and unusual punishment. And what lockdowns essentially are is where the institution puts everybody, all the inmates, they have to go into their cells and they're locked into their cells for whatever period of time the institution chooses. And it can be, and again, as the slide says, it can be for things like staff shortages. So if any number of correctional officers are sick or call in and say they're not coming in, and the administration doesn't think that it has enough officers to basically handle the prison population, they'll lock them down, and which is an enforced segregation for not just somebody in solitary, but for everybody. So it's an incredibly actually often used kind of thing. Lockdowns would also be used for security issues. So for something like after everybody's meal, they have to return their knife and fork to the correctional officers. They're not, knives and forks in jails and penitentiaries aren't like the knives and forks that we use. They're certainly not steel, and they don't have any sharp edges. They tend to be made out of rubber or plastic. And so, they do the job. You can eat with them, but again, they're certainly modified for prison use. And even though in and of themselves, they're not harmful or a weapon that can be used, excuse me, they can be used if they are basically shaved down or what have you to a sharp edge. So, it's incredibly important then obviously for the institution to collect all these possible implements that could be used to cause harm. So lockdowns will happen if if a fork or a knife, even if it's plastic or rubber, is not turned in at the end of the meal. Likewise, sentencing judges have found harsh conditions with respect to, again, people awaiting trial who are put into lockdowns, overcrowding, violence that's condoned in that the correctional staff doesn't stop, a fight, for instance, that takes place and somebody's certainly going to be hurt, and all those things. All of they still all fall within that rubric of a cruel and unusual punishment. All right, let's go through the Mandela rules, just those relative rules that are important regarding solitary. So it's rules 43 to 45. So rule 43, in no circumstances may restrictions or disciplinary sanctions amount to torture or other cruel, inhuman, or degrading treatment or punishment. So clearly that's a very broad assertion of that policy. And specifically how that works in practice is that that statement basically, these things should be prohibited. Indefinite solitary confinement, so again, that's solitary without any end date. Prolonged solitary confinement, which means confinement past a certain length of time that is deemed to be appropriate. Placement of a prisoner in a dark or constantly lit cell. That's a really interesting provision because I can tell you that in all provincial jails, for instance, in Ontario, it is never dark. Even at night, when you go to sleep, the lights are turned down a little bit, but so they're not exactly the same as they would be during the day, but it's certainly more light than dark. What this does is it allows correctional staff who walk the range at night to look in through the small windows in the doors to make sure that the inmates are sleeping for the most part, or certainly aren't doing anything to cause themselves harm. So it facilitates that kind of thing. So it's a safety issue, but again, it's a human rights issue because if you can't get a proper night's sleep, it's going to affect you mentally and physically over the course of time. Likewise, corporal punishment, which is physical punishment, is contrary to Rule 43. Rule 44, for the purposes of these rules, solitary confinement shall refer to the confinement of prisoners for 22 hours or more a day. And again, we know in Canada and Ontario, we do solitary involves more than that, without meaningful contact, which means you really don't have contact with anybody. So even with correctional staff, the correctional officers, your only contact with them is them opening a little door in your in your cell door and passing food to you. That's all the contact you're going to have. You're not going to have access to phones to contact family or what have you. And prolonged solitary confinement shall refer to confinement for a period of time in excess of 15 days. So that's what's beyond that is considered to be cruel and unusual, basically. And Rule 45. Solitary confinement shall be used only in exceptional cases as a last resort, which clearly it basically says it shouldn't be used for administrative purposes. It should be for as short a time as possible and subject to independent review, which means somebody from outside the jail should have oversight for solitary, and that's important because that is one of the things that the federal government is looking at putting in place when, as a function of adopting the Mandela rules, basically, and it should not be imposed by virtue of a prisoner's sentence. So, certainly no sentence in the Canadian Criminal Code refers to, a sentencing judge putting somebody into a solitary after they've been convicted. All right, and the second part of Rule 45, the imposition of solitary confinement should be prohibited in the case of prisoners with mental or physical disabilities, or when their conditions would be exacerbated by being in solitary. The prohibition on the use of solitary should not involve women and children. All right. So obviously we said this earlier, but those are the rules that have been adopted. Those particular parts of Mandela rules are not going to be part of the federal government's adoption of these policies. All right, we now have this case I posted on CMS for you. It's a Canadian Civil Liberties Association versus Canada, Canada being the federal government and how the federal government operates its prison system. It's a decision of last year in the Ontario Court of Appeal. And the Ontario Court of Appeal, when it sits, it has 3 justices who hear appeals, and appeals obviously are heard from decisions made at a lower court. So it's, most often in the superior court in whatever province or territory hears a matter. And so this is the Ontario Court of Appeal saying that a distinguishing feature of solitary confinement is the elimination of meaningful social interaction or stimulus, and it has the potential to cause serious harm, which could be permanent. So that's a recognition by the court. Federal legislation permits its use in penitentiaries across Canada. We know this. It's called administrative segregation and is used to maintain safety and security or to conduct investigations. So in this particular case, the appellant, that's the body who brings the appeal, the CCLA submitted that section 31 to 37 of, and this is the statute that deals with a great deal of authority dealing with prisons in Canada, the Corrections and Conditional Release Act. The argument was that those particular provisions basically are unconstitutional, and again, they're unconstitutional by virtue of Section 7 and Section 12 of the Charter, right? So the Ontario Court of Appeal accepted the conclusions of the judge in the Superior Court with respect to young inmates between 18 and 21, those with mental illness, and those placed in segregation for their own protection. So here, what the Ontario Court of Appeal was basically saying is, when it comes to these particular inmates, the way that the Correctional Services of Canada deals with them in regard to putting them into segregation is not cruel and unusual punishment. However, prolonged administrative segregation for more than 15 consecutive days does not survive constitutional scrutiny, which means it does in fact violate the charter. So that's important. That's what the decision said, is that in fact there's no question that prolonged segregation is cruel and unusual. The safeguards put in place by the federal government in that act we just saw don't do the job to avoid the risk of harm, and they believe that in fact the practice dealing with prolonged segregation outrages standards of decency and amounts again to cruel and unusual treatment. The PowerPoint, or the YouTube video you now see on this section of the PowerPoint, this is an interview of Howard Sapers. He is probably the most well-known and most knowledgeable person in Canada dealing with the issue of segregation. For a good period of time, he was the Federal Corrections Investigative Officer. And then when that job came to an end, the province of Ontario hired him to, in fact, for a 3-year period, to look very specifically into the effects of solitary confinement in Ontario provincial jails. So when you get a chance, I'm not going to post this. I'm not going to run this during this lecture, but if you do get a chance, and this is a topic that really interests you, please watch this video because it is absolutely excellent. So you'll really learn a lot by listening to Mr. Sapers. I can tell you that while he was appointed for a 3-year term in 2016, to do this investigation when Doug Ford became the Premier of Ontario in 2018. He brought this position to an end. Ford had no intention of looking into anything more relative to this particular job. So that's a shame. But having said that, this interview is still a very valuable thing to take a look at. Okay, so the next thing we're going to talk about, this is the second segment of this lecture, it's probation. Right, so probation is something that we've talked about. We talked a lot about it last week when the choices of sentencing. So as you already know, probation is available in concert with other sentencing options, things like conditional discharges and conditional sentences. So you already know that in both of those kind of sentences, when conditions are imposed, they're going to be imposed as a function of a probation order, right? And the conditions are going to be in that order, pretty much established with the assistance of what's going to be a pretrial sentencing report, and then put in place at the judge's discretion. We also have probation as a stand-alone sentence, and so with the way that works is that the judge will pass a sentence that he or she thinks is appropriate on the basis of a conviction. Again, the conviction being either a plea of guilty or, after a trial, a finding of guilt. So in both of those cases, there is the prospect of probation. It's highly used as a sentence. And what the judge does is he passes the sentence, and then so it could be a fine or it could be a term of custody. But when he or she passes that sentence, they will then suspend the sentence, meaning that it doesn't come into effect as long as the probation order that is put in place is adhered to. So it's virtually just probation. How probation has been granted over time and how the considerations going into what the conditions will be has certainly changed over time. Traditionally, probation officers, then they are the practitioners in the field that deal with probation. The historic way that has been done is with the probation officers meeting personally with the offender and interviewing them, asking them all kinds of questions that they think are appropriate, talking to their families, checking into their employment, checking into their communities. So for instance, that would be incredibly important if, for instance, an Indigenous offender is having a probation, a pre-sentence report prepared, and they live on a reserve, so the probation officer would likely visit the reserve, talk to the elders, and what have you. That's the traditional, that's a discretionary system that's been in place. But over the course of time, the discretionary system has been replaced, or at least supplemented, by what's considered to be an actual risk assessment. So actual is basically a number crunching process where, in fact, the probation officer uses an assessment tool. We'll talk about what that tool is in a few minutes, and actually assigns scores to certain behaviors, and then adding up these scores, which are believed to, lead to, the risk of somebody committing a crime, recidivism. They count on these scores to basically say this person should or should not be released in society, and if they are going to be released, here is the level of conditions that should be imposed to keep both the public safe and the offender, living in society in a lawful manner. So what essentially has happened is that risk assessments and actuarial practices have basically replaced, to a great degree, the ways that judges and correctional policy deal with the issue of putting conditions in a probation order. So risk technologies over the course of time have considered to be superior to unstructured clinical judgment. That unstructured clinical judgment is what I just described as the discretionary process that a probation officer takes. And this describes that clinical process, the exercise of educated intuition, where information items gleaned from interviews, client history, psychometric instruments, and conferences with other professionals are engaged at the discretion of the individual carrying out the assessment. So that, again, as the traditional way that probation officers have done their job to assess the the viability of a particular person being released and those conditions that will attach to that release. And that has now been again supplemented by risk technologies. So what's happened is that jurisdictions across Canada are using risk assessments to inform all kinds of decisions, not just probation. So things like arrest and bail decisions, and they inform police and parole, probation, and customs officers in making decisions that obviously affect how a person can interact in society. So practitioners, these being, for the purposes of today's lecture, probation officers, they both actively resist and they embrace risk technologies. So they now realize that the risk assessment tools are something that they can't avoid. It's the present and the future. But having said that, while it's something that has been alien to them, they do know that they certainly have to adopt their use to justify the kind of reports that courts are looking for. But they look at it as risk tools that shape or supplement discretion and not eliminating discretion. Risk tools for practitioners are looked at as a positive thing, in that if they are ever questioned with respect to a decision they make, and that kind of questioning really only takes place if somebody has been released on probation and, for instance, they commit another crime, and particularly if they harm somebody. So if that happens and the media, for instance, becomes aware that the person is on probation, the public is going to cry, why would you possibly let this person out into society? And what these risk tools and assessments do is they give an objective standard that the probation officer can simply say, scientifically calculated that this particular person would not be too high of a risk to be in society. So they rely upon risk tools to justify decisions. The model that is used universally for the most part with respect to risk assessment is called the R&R model, which basically has redefined how probation officers produce, interpret, and apply risk knowledge. So it's a very well-established model. It has very specific components to it that are risk assessment tools. In Ontario, all probation officers have to complete a risk need assessment using the R&R model in preparing a pre-sentence report for the court to use at sentencing. And you remember when we talked about sentencing and probation last day, these kind of reports are generated for the most part when the defense asks for one. The Crown's very seldom ask for one, but the judges can ask for a pre-sentence report on their own volition as well. The risk principle is an endorsement that criminal behavior is predictable, and that is the crux of a risk assessment tool. That everybody's behavior can be predicted in the future, and if we look at the risk factors that go into that involves people's personalities and their behavior, that those risk factors can be calculated to create what's called a level of risk, and that level of risk obviously will determine a recommendation that a probation officer may well make. Basically, high risk are those that have what are considered to be the greatest number of interventions, either in institutions before or when they've been already released previously on bail or parole, those kind of things. What this simply means is that the more active somebody has been in the criminal justice system, active meaning coming to the attention of either the courts or administration, the higher risk they become. That's just a behavior that is a risk factor. Right, so that's the risk part of the R&R model. The need principle relates to the importance of targeting what are called criminogenic needs and providing treatment to reduce recidivism. Recidivism being the recommission of a crime after one's already been committed. And these are the factors that are looked at. So, and each of these has a score attached to them. So you'll look at somebody's employment record, their marital family relations. So in that regard, your score for risk will be lower if you are married or in a relationship. That's evidence of social skills, which obviously are good things in a risk assessment. But if you're single, your score will be higher. You're more at risk because, again, it's looked at as evidence of not necessarily having good social skills, your social interaction. Clearly, substance abuse are risk factors, personal emotional orientations, and all those kind of things. So these are the things that are criminogenic factors that, again, have numbers attached to them that will, be compiled to come up with your risk assessment. Professional discretion as a function of that is now simply seen to be something that is in place, but to be structured around risk tools. And in many cases, it is the risk assessment component of an assessment that is seen to be the most important thing to look at over and above clinical judgment. And the last R in the R&R model is the responsivity principle that simply requires correctional treatment to be delivered in a style and mode that is consistent with the ability and learning style of the offender. So responsivity means, how a offender will respond to treatment for the most part, basically. So those who are proponents of this actuarial risk assessment tools basically see that not using them and only using a clinical judgment is basically not a defensible policy or practice. And again, the Ontario government accepts that position, so nobody can any longer just use that unstructured discretion. So risk need assessments basically are adopted, and clearly, again, they're based on the assumption that criminal recidivism is predictable, right? So people's offenders, by giving a score, can give a predictable estimate of how they're going to basically properly reintegrate back into society. So the risk assessment tool again gives a score. So it's a numbers game to a great degree. And in definitional terms, and this kind of risk assessment is a score, which is what's called a probabilistic calculation tested on aggregate groups. And aggregate groups means that over the course of creating the R&R model, the scores that are attributable as risk factors are looked at as how they would apply to large groups of inmates as a whole. Right, so it's scientific in that it addresses risk factors with levels of risk by way of numbers, but it's very broad in that assessment in that it deals with large groups of inmates. For institutions faced with declining resources, so this is really important in Ontario jails where the budgets are being cut, then using these kind of scores is a convenient rationale for restricting programs and what have you. So it basically reduces the amount of time that, for instance, the government has to pay probation officers to actually meet with and talk to inmates. So the score is used as a quick and dirty kind of tool, which is relatively cost effective. So risk assessment basically is more than simply management of the offenders. It limits the number and range of treatment options available to practitioners. So again, it is the least expensive and easiest way to create a risk assessment. Some probation officers, practitioners feel that these tools are simply qualified or quantified common sense, and that should be easy to understand. All of these things that we're talking about, an offender's ability to be in a relationship, their employment history, their interactions in the criminal justice system, all of those things, even if you weren't using a tool that is considered to be scientific, that assigns a risk factor and a number to that factor for recidivism, all these things still seem to be common sense. You would think that if somebody lives on their own, has had a lot of interactions in the criminal justice system, has substance abuse problems, without even applying a risk assessment, you would simply say, yes, we kind of think that person may well have a more difficult time reintegrating back into society than somebody who doesn't have those particular behavioral issues. All right. So again, what's happened is that over the course of time, probation officers have now taken an approach where the discretionary process that was traditional is now combined with the statistical and clinical approaches. So in fact, they work together, and that's a good thing. Obviously, that gives a more comprehensive response to it. And the last point in this particular segment on risk is this very short video on, in fact, what is risk? You know, how does risk actually work with respect to coming up with an assessment for the purposes of considering somebody's ability to safely and properly reintegrate back in society. So that's only 8 minutes and change, so watch that if you get a chance. The last segment we have in today's lecture is on parole. So parole, we haven't talked a lot about this in this segment on sentencing. So what parole is simply this: every inmate, doesn't matter whether it's in a provincial jail or a federal penitentiary, almost every inmate has the availability of parole at some point during their sentence. So inmates that basically are looking for parole, 1/3 of the way into their sentence, most of them have what's called the ability for discretionary release, which means they can apply for parole after only serving 1/3 of the sentence. After 2/3 of a sentence, all inmates are virtually automatically released. This doesn't apply to things like life sentences, and we'll talk about that in a second. But most determinate sentences, those with fixed dates, everybody's released at the 2/3 point. That's called statutory release. And the term warrant expiry date is just a term that says that the warrant expiry date is the last day of a inmate's actual sentence. All right. So there is a need to keep accurate data on how parole works to ensure that, in fact, its position in the criminal justice system contributes to either crime in that it doesn't work, or it contributes to positive reintegration in that it obviously does work. An effective parole system can promote community safety, which means that those who are basically being allowed to reintegrate into society during their sentences can do so safely and do not cause harm to the public, and at the same time that they can successfully reintegrate into society as a function of whatever terms of parole are put in place to allow them to do that. We should distinguish between federal prisoners and those sentenced to provincial or territorial jails, essentially, because the parole systems are somewhat different. So federal prisoners fall into two categories: those serving what are called determinate or fixed sentences. So what that simply means is it's a sentence with a fixed term, 2 years, 4 years, 10 years, that kind of thing. Obviously, as you already know, federal inmates are going to a penitentiary if their sentence is more than 2 years. And we also need to know that there are sentences in the penitentiary system that are called indeterminate, which means they have no end date. And the latter category of indeterminate sentences are life sentences for murder, which we've already talked about in a good deal of detail last day, and likewise indeterminate sentences for dangerous offenders. So the dangerous offender application is made by the Crown after a sentence is imposed by a judge. So it's a supplementary hearing to affect the sentencing. And what it simply means is that if a court determines that somebody is a dangerous offender, and this isn't something that's used an awful lot because the burden on the Crown to prove this is in fact quite high. But if a court does accept the application that a certain person is a dangerous offender, then their sentence is indeterminate in that there's no end date to it. So obviously it's a very serious kind of supplement to a sentence. All provincial and territorial prisoners are serving less than 2 years, so the term is called 2 years less a day. You already know that, right? In the federal penitentiary system, all release on parole or day parole, and I'll tell you what that is in a few minutes, is determined by the Parole Board of Canada upon an application by the prisoner after reaching a statutory eligibility date, which will be the 1/3 or the 2/3 markers. The Parole Board of Canada has been in place since 1951-52, so it has a great deal of experience in dealing with parole and actually other issues like record suspensions and what have you. But having said that, it's very well established. They have parole board members who are basically available in every penitentiary in the country, because parole board hearings actually take place within penitentiaries. And in the provincial sphere, only Ontario and Quebec have their own parole boards, but they're designed in the same model as the federal model. Their job is much more circumscribed than the Canadian Federal Parole Board. Far less inmates are eligible for parole in Ontario. I'll tell you why in a second. And a great deal of difficulty, for instance, in the Ontario system is that the Ontario government, over the course of time, to fill positions on the parole board, and it's a paid position, so it's something that people would necessarily like to obtain. They tend to be filled with people who they believe have personal knowledge of the criminal justice system, which is going to mean that the parole board is made up of retired police and retired correctional officers, and they make up a good deal of the membership of the Ontario Parole Board. That's, and you can understand that's inherently difficult for an inmate, because you're going before they sit in pairs for the Ontario Parole Board, and so you're making your argument that you should be released earlier than your warrant expiry date or your 2/3 statutory release date. You're making that argument to somebody who likely isn't very sympathetic to the position of a inmate who has committed a crime. All right, so having said that, that's what they have to live with in Ontario. So apart from Ontario and Quebec, the rest of the provinces basically employ the Parole Board of Canada to make decisions for provincial inmates. All right, all prisoners on parole, regardless of where they are, whether it's the provincial system or the federal system, are subject to conditions imposed by the parole board. So they, it's not unlike probation in that regard. And these conditions are going to be in place for the balance of their imprisonment, which means they go to the end date of their warrant expiry date. And conditions and supervision on parole certainly includes the power for parole officers to seek to suspend, revoke, or return somebody to prison who they do not believe should any longer be entitled to be in society as a function of that parole decision. For federal prisoners serving fixed sentences, determinate sentences, again, the same act that we dealt with respect to solitary is relevant federally. So it's the Corrections and Conditional Release Act. And again, what it provides is that if somebody has served 1/3 of their sentence, they are eligible for what's called full parole. And full parole simply means that it's not day parole. And day parole, again, I'll discuss shortly. That's replicated in provincial jails for prisoners. The difference being is that in provincial jails, you are only eligible for parole if your sentence is at least 6 months in length. The statistics show that the average length of somebody in a provincial jail, their sentence is 60 to 90 days. So clearly it's a minority of prisoners in provincial jails that are serving 6 months or more. But if they do, then they can apply for early release after serving 2 months. That's the 1/3 of the 6 months, and they will automatically be released if the sentence is 6 months after 4 months, if they don't get the benefit of a parole board decision granting early release after 2 months. Okay, so hopefully that's straightforward. For murder, again, this is in the federal system. You already know this, that somebody who's convicted of first or second degree murder is sentenced to life imprisonment. All right, so that's an indeterminate sentence. It has no end date other than the person's date of death. And having said that, they are ineligible for parole for first degree murder for 25 years and for second degree murder based upon a jury's recommendation. We talked about that last day. The judge has the discretion to accept or not that recommendation, but can impose a parole ineligibility period of 10 to 25 years for, again, second degree murder. And again, federal prisoners will be released if they have determinate sentences at the 2/3 mark of their sentence. So if somebody is sentenced to 12 years in a federal penitentiary, then if they don't get early release after 4 years has gone by, they will be released with very few exceptions after 8 years has been served. And again, the remaining 4 years of their sentence is going to be served on parole with whatever conditions are put in place by the Parole Board of Canada. So the whole argument behind the benefit of parole is that prisoners who are released on it are basically seen to be released gradually into society with mechanisms, those would be in the conditions of parole, that provide support for the inmates and controls over their actions. So it basically offers what's considered to be a transition from prison back into the community. And research has consistently shown that a conditional release or a transition back into the community is a much more effective way to have a prisoner reintegrate successfully into society and become a law-abiding citizen, which means they don't recidivate. All studies have basically shown that that is a far superior way to basically get a prisoner reaccustomed into what they need to do to successfully live in society, than simply have them in prison to a fixed date, and then it's what's called sudden freedom, which means there are no conditions attached to it. So that's clearly seen to be not the way to successfully do a reintegration. Some people, and this of course is an opinion that was held during the time that Stephen Harper was our Prime Minister from 2006 to 2015, and again I mentioned this before, where he had a tough on crime agenda. During this period of time, the federal government took the position that the opportunity for offenders to serve part of their sentences, i.e. on parole, in the community basically was too lenient. That's not something that was seen to be appropriate, and that was supported by a good deal of the public because that was the position that was promoted by their government, and so in fact, obviously, the parole system came into question under Stephen Harper, and we'll talk about that in a few minutes. The controversy regarding that particularly became important with respect to the issue of day parole. So day parole is simply this, that somebody is released into the community earlier than certainly the 2/3 statutory release, and they get to go and live in the community, work, obviously, but at night they have to return to either the institution, if they are working close to that institution, or if they're away from an institution, they return at night to what's called a halfway house. Halfway being you're halfway into the community and you're halfway still institutionalized, right? And so the Harper government really took an objection to this kind of provision, because again they saw it as being too lenient. Their position was, and they did a number of things to promote this, was that if somebody is sentenced to a term of 10 years, they should serve, for the most part, that fixed term of 10 years. That was what they saw to be what they called truth in sentencing. Now, having said that, day parole is only going to be allowed for anybody for the 6 months prior to their parole eligibility date. So if they are granted discretionary parole after 1/3, then it doesn't automatically go into effect at the day that parole board makes the decision. They can basically say your parole release will be 12 months from now, kind of thing. If that's the case, 6 months before the end of that 12-month period, they can have this gradual release in society as a function of day parole. Or if it's somebody who wasn't getting discretionary parole after 1/3 and they have to wait to their statutory 2/3 release date, they could well be eligible for day parole 6 months before that 2/3 period comes into effect. So that's how day parole works. And having said that, just back up here a second. Having said that, what the that wasn't changed particularly by Harper, but what Harper in fact did change is what's called the availability of accelerated parole for those who commit non-violent offenses. So what that was is basically anybody who was convicted of theft or fraud or something that involved money for the most part, but did not involve harming anybody. We had a system of accelerated parole where they only had to serve 1/6 of their sentence, and then obviously the remainder of their term is on parole. Usually a lot of that, again, dealing with halfway houses and what have you. The Harper government did in fact do away with that. So that is no longer a provision. So nobody can only serve 1/6 of their sentence, even for crimes that in fact aren't involving violence. So they did get rid of that. They did not have time to get rid of the conditional release system at 1/3, which they really wanted to get rid of. What happened was that while they were proceeding to in fact pass legislation amending the act that we referred to earlier, dealing with the federal system on prisons and penitentiaries, while they were preparing to do that, an election was called in 2015, and and the Harper government lost, and Justin Trudeau was elected. And so Trudeau has absolutely made no movements whatsoever to basically reiterate or invigorate that kind of process that Harper was looking to do away with. In 2009, again, remember this is in the middle of the Harper regime, 60% of Canadians thought that sentences were not severe enough. And again, that fed into that kind of tough on crime agenda. And likewise, with that kind of mentality, a good deal of Canadians also thought that the parole system was too lenient, but that's in great terms has been seen as a blip on the philosophy attending the use of prison systems to rehabilitate offenders. So for the most part, and certainly since the enactment of the Criminal Code of Canada in 1892 going forward, most Canadians have a deep distrust of imprisonment as a solution to crime. So, and I've said this earlier, clearly what happens is that there is nobody who goes into a provincial jail or a federal penitentiary who goes into that particular institution and comes out a better person. It just doesn't work that way. They almost always come out worse off than they were when they went in, which obviously is an issue for recidivism upon release. So, the only way to countermand that kind of thing is to, in fact, support a reintegration as a gradual measure. So in conclusion, with respect to parole, it serves two crime reducing, and obviously that's important for this final segment of our class. So the two crime reducing functions are, firstly, it gets people out of institutions which are going to make them worse. And secondly, it provides for a controlled and supported release of prisoners into the community. So it allows for a gradual reintegration, which all criminological studies have shown is really the best way to ensure that inmates getting back to society can do so successfully. And those particular 2 points, those opinions are, basically for those who are informed on how the system works, which now obviously includes you. Everybody recognizes the benefits of doing it that way. The last thing we have in the lecture is a very short video on an application that Paul Bernardo made a couple of years ago with respect to his application for parole. He has now served more than his 25 years of parole and eligibility, so he has the right to apply for parole. So what this video shows you is what happened in his parole hearing, how the victims of the teenage girls, Kristen French and Leslie Mahaffey, how the parents reacted to his parole hearing, and it gives you a fairly decent glimpse on the workings of the system. All right, guys, again, thank you very much. I will now be posting a Google form online for you to please basically respond to me, telling me that you watched this video, and as a function of that, you'll get a 10 out of 10 for today's participation. And once again, next week, I will post a documentary for you to watch and give you a very short opinion piece as an assignment in that regard. All right, guys, thank you. I appreciate you watching this video, and we'll see you later. Thank you.